Order. Welcome to this first session of the Justice Select Committee for 2026. This is the first public session in relation to a new inquiry which is into access to justice. The first session is about legal aid and sector sustainability, which I'm sure will have explained to us. I'm going to ask our witnesses to introduce themselves, but before we do that, as usual, we will have the members of the committee giving their declarations of interest, starting with Warren Just.
Good afternoon, I'm Warren Just, Member of Parliament for Wolverhampton West. Relevant to today's session, before becoming an MP, I worked as a personal injury and clinical negligence solicitor for Thomson's, a trade union law practice. I'm also an executive council member of the JMB trade union and a member of various APPGs.
Good afternoon, I'm Pam Cox, I'm the Member of Parliament for Colchester. My interests are, as declared on the register, I would just add that I am the chair of the APPG Penal Reform.
Hello, I'm Tony Vaughan. I am a barrister, and before I came to become a Member of Parliament, I practiced a lot in civil legal aid. I am an associate tenant at Doughty Street Chambers. I draw attention to my register of interests, and actually also relevantly, I also used to be a legal aid funding adjudicator.
I'm Andy Slaughter, I'm the chair of the committee, the MP for Hammersmith and Chiswick. I'm a non-practising barrister, a member of the GMB Unite Trade Unions. I'm the patron of two justice-related charities, the Upper Room for Ex-Offenders and Hammersmith and Fulham Law Centre.
Hello, I'm Lindsay Farnsworth, Member of Parliament for Amber Valley. My interests are per the Declaration of Interests Register, but of note, I am a former Crown Prosecutor. I am a member of the Access to Justice APPG, and I am co-chair of the APPG for Legal and Constitutional Affairs.
Hello, I'm Vicky Slade. I'm Member of Parliament for Mid Dorset and North Pool. My interests are as per the register, but I have no relevant interests.
Good afternoon, my name is Neil Shastri-Hurst. I'm the Member of Parliament for Solihull West and Shirley. My interests are as per the register. In addition to that, I would note that I'm an associate tenant at number 5 Chambers, and I was a former officer of the APPG on Access for Justice.
Good afternoon, Ashley Fox, Member of Parliament for Bridgewater. I'm a former solicitor, and my interests are as on the register.
Thank you very much, everyone. So, as I said, I will ask each of the witnesses in turn to introduce themselves and give a brief overview of the organisation they represent as it's relevant to today's proceedings, starting with Rohini Jana.
Good afternoon, everyone. My name is Rohini Jana. I am a Director of Policy for Legal Aid Practitioners Group. We are a membership organisation which represents the interests of legal aid practitioners across England and Wales and across various practice areas. We also provide the Secretariat for the APPG on Access to Justice.
Good afternoon, my name's Kirsty, Brimelow. I'm the chair of the Bar Council. The Bar Council represents around 18,000 barristers now across the jurisdiction of England and Wales. And I'm new in post, having been vice chair last year. And as a practitioner, I practice from Doughty Street Chambers in international human rights, public law and criminal law.
I'm Richard Miller. I'm head of the Justice team in the Policy Directorate at the Law Society of England and Wales. We represent around 200,000 solicitors practising across all areas of law in the country. We don't have exact numbers for those practising within legal aid and access to justice areas, but I think a reasonable estimate would be in the region of 20 to 30,000 of them. And my personal background, I've been working in policy issues related to legal aid and access to justice since the year 2000.
Thank you very much. We're going to talk quite a lot about legal aid this afternoon, but the brief of this inquiry is considerably wider than that. It's access to justice more generally. Perhaps you could start, each of you, by defining what you mean by access to justice and how the work of your organisations fit within this. Perhaps we'll start in reverse order. Mr. Miller.
Access to justice requires, first of all, that people who have a dispute have a mechanism for resolving that dispute. Now, we would say necessarily that must involve a court or a tribunal. That's not to say that every dispute has to go to those, but alternative means of resolving disputes will only be effective if there is ultimately a court or tribunal which can resolve the matter in default of agreement between the parties via some other mechanism. It also requires that people have access to the support they need in order to be able to navigate the systems for resolving the dispute. Now, in some cases, that support may be limited to just a bit of information which they can access and then resolve things for themselves. Others will need more intensive support, including direct advice, casework and full representation. And so legal aid also needs to be available to ensure that those who need that sort of support but can't afford it for themselves are able to have access to it, because otherwise only the rich and the powerful will have access to justice, and that is not a justice system as we would understand it.
Ms. Bruno?
Thank you. Well, if I perhaps start on a more of an overall looking at the contract, the sort of society contract, and then come on to practicalities very briefly in this short time. Access to justice is one of the key pillars of a functioning liberal democracy, and it also links to a society that functions well. It links to rule of law. What's rule of law? I always like, in fact, some of the philosophical links to it being one of the stars in the constellation of political morality, and often you'll see that intersection. Practically, what does it mean? Well, on a level of a person who's got some dispute or has a dispute forced upon them, or is some of their rights are taken away through detention, for example, they then will look at what remedies they have, and they can vary in terms of urgency. What do barristers do? Well, they deliver advice through usually through being instructed by solicitors, also through direct access. There's increasing numbers of direct access cases, public and barristers are publicly available to be instructed. The advice can turn into advice which is taking the case to court, but much of that also will depend on what the risk is to the person on some disputes, and that will look at what is their cost risk, and this is where legal aid comes in. Legal aid currently, as we'll come on to in terms of eligibility for legal aid access, really is only applying to those at a very low income in terms of means testing. And so therefore that means that lots of cases where people are engaged in different disputes are cases where the person is not eligible for legal aid, has a huge cost risk facing them, and therefore has an obstruction to accessing any remedy and any justice. And that is one of the issues. If the case goes to court, barristers deliver justice for both sides at court, and many barristers work on a pro bono basis on different schemes to start the case going. Many still work on civil legal aid and criminal legal aid, but overall there is an issue with retention of barristers working in those areas. And again, I'll come on to that in more detail. I think finally, coming back to where I started, it's hugely important, and we'd like to see justice and legal aid being on the same footing as services through education and through health.
Ms. Jana.
I'm going to concur wholeheartedly with everything that Mr. Miller and Ms. Brimelow have said thus far. But what I want to focus on is, to me, access to justice is whether an ordinary person at a stressful moment in their lives can actually understand their rights and they can get meaningful help to enforce them. We talk about the rule of law rather a lot in our world, but essentially this is a means of ensuring that those in power, be that the decision makers at the DWP, in the Home Office or local authorities, both act and are seen to act lawfully and with integrity. Access to justice gives us the mechanism by which, when they don't, we have the ability to redress this imbalance. As Ms Brimelow said, access to justice is a fundamental pillar of our society. It's a huge part of how we think of the society that we want to create. And legal aid, as you mentioned, Chair, is the mechanism by which we use to deliver it. It's a vital public service, as Ms Brimelow said, just like healthcare, just like education. And in the same way that we wouldn't tell someone with a complex medical need that they should go away and diagnose and cure themselves, we should think once again about the fact that we are asking hundreds of thousands, if not millions of people to do just that when we remove access to justice via legal aid or alternative methods of obtaining legal advice and representation, as we have done through the cuts that have been made to the system over in recent years.
Thank you. A lot of civil legal aid is currently governed by Legal Aid Sentencing and Punishment Offenders Act, LASPO. And under that Act, the Lord Chancellor has a statutory duty to secure that legal aid is made available. To what extent is the Lord Chancellor meeting that statutory duty to secure the availability of legal aid? Again.
I think that is a very challenging question because it's at a very high systemic level. The evidence that we see shows that there are huge gaps in access to justice across the country. So, for example, we have mapped advice deserts across the country, areas where the general public don't have local access to the legal services they should be entitled to. So, for example, over 40% of the population do not have access to a housing provider in their local authority area. And these are the people who can't afford to travel to get the advice they need. Where there are court proceedings, you need a person in person, so remote advice can't be the answer here either. Not having that local provision is a major problem. But the statutory provision is quite high level, it's quite vague. It has been used to challenge the Lord Chancellor in the past. So there was a case brought by Duncan Lewis about 18 months ago where they alleged that the Lord Chancellor was not meeting his statutory duty in relation to immigration advice. The Ministry of Justice actually chose not to fight that case and brought forward proposals for an increase in remuneration rates to address the concerns that Duncan Lewis had expressed. We also raised this argument in relation to our judicial review on the Bellamy report and the fact that the Ministry of Justice ignored Bellamy's findings and put forward a much lower increase for criminal legal aid lawyers than was required. And in that case, the court actually said they did not consider that the Lord Chancellor had failed to meet his obligation, but they also came out with some very strong language to say that if there was not a significant investment in legal aid in the near future, it would not be unreasonable to say that the system was approaching the point of collapse. So it felt like they were saying, no, not yet, but we're not that far away from this. Now, I think it is one of the concerns about this duty that the only way to enforce it is by way of judicial review, and there's only a limited number of bodies who actually would have standing to bring a judicial review of that nature. So it's not an easy issue to hold the Lord Chancellor to account for failing to meet this particular obligation. But I think the fact that it's been raised on both the civil and the criminal side, and there have been some clear warnings here that the point of breach may be close, shall we say, I think is very telling. And the fact that for large swathes of civil legal aid, we have still had no increase in remuneration rates. We are still seeing year on year firms, lawyers pulling out of this work. It does, I think, raise some real red flags about whether the Lord Chancellor is meeting his duty here.
I want to add to that.
If I could just add to that there is a duty, and you'll know the duty under the Legal Aid Sentencing and Punishment of Offenders Act 2012 Section 1. So that sets out the Lord Chancellor's functions, which includes ensuring that legal aid is made available. So and also the oath of Lord Chancellor includes that. The points I would like to make on why that is not being met is because first of all, we have LASPO, which failed to align with the recommendations from the Jackson Review. What that means in particular is that where legal aid was available previously, they are now out of scope of LASPO. They are very serious and important cases, and they predominantly cluster around human rights claims against the state, which don't have a personal injury element to them. So I can give an example. One case which was very well publicised not that long ago related to an actor who'd actually was quite famous for having played Billy Elliot when he was younger. He wanted to bring a claim for false imprisonment against the police and also an assault claim. Because he, in terms of the means testing, it meant that he wasn't somebody who was on the income support on that sort of bracket. It meant that he had to consider that if he lost on the false imprisonment claim, even though the advice was 80% you are going to win, you have a very strong case here, he still had to consider that 20%, which potentially would loss of his house. It was on a modest income, but impactful to him. So therefore, the claim went ahead on the basis of assault only, which comes within LASPO. The result was that the finding was such that he would have won on the false imprisonment. So he was deprived of damages on false imprisonment because of that, the way LASPO is set up. That has an extra impact, and that impact is that it affects decision makers, because if our public law decision makers, people making these very powerful decisions, particularly around enforcement and using delegated powers, if they know that the chances of them being challenged are really pretty minimal, then that is going to affect it'll bring arbitrariness to their decision making. So there's a wider public interest that there is a means to hold the state to account, and that includes obviously all the different public authority and state bodies. And that's one example, a very clear example, where he was deprived of access to justice on a very serious violation there relating to false imprisonment. The other point I'd like to make, and this has been touched upon by Richard Miller, relates to the exceptional case funding. It is so low that the difficulty is the obligation on barristers to take those cases under exceptional case funding is such that they have to be prepared to work at extremely low rates. The rates are lower than you will get in crime, and that is a very low bar. And that's not only from my experience, but it's from the experience of barristers, that we represent, and also my colleagues at Doughty Street Chambers. One example was given to me on one case with a practitioner, junior practitioner, working under exceptional case funding, and she calculated that she was being paid £2 an hour, and clearly it's not sustainable. Impact on that, and we'll come on to this no doubt looking at the Hillsborough law, the impact on that is you are going to lose capacity for lawyers to take the cases. Already with Doughty Street Chambers, where I did a check with them, because that I think is probably the biggest set for in representing families. It's a bigger set of chambers for family representation in England and Wales, and they already cannot cope with demand of cases. The way you can increase specialist barristers dealing with these cases, such as human rights violations, including inquests, which is super important, is to increase the ECG to a reasonable rate. We would say that that rate should at least be equivalent to what the state barristers are being paid. So, give an inquest as an example. In an inquest, quite often you will have, so you're representing the family, you will have perhaps 7 barristers effectively all against you, representing all the interested persons, and they can go from the fire and rescue service to different NHS trusts to perhaps Ministry of Justice to police, whoever's involved, ambulance service and so on. And you do feel, and this is the message that we're getting from members, you do feel outgunned, and that will then come back to a principle of fairness and equality of arms, that the setting right from the start is disadvantage to those who don't have the legal aid, or who don't have wealth so that they can pay for their own private representation. So we've got a lot of people in the middle who are outside LASPO, and that was the example of I call it the sort of Billy Elliot case. We have the legal aid rates that are already there, which are way too low. They're even below criminal legal aid rates. And then we've got the effect that the opposition, if you like, in these cases include many barristers acting for different bodies of the state who are properly paid. And why can that not be levelled up?
Yeah, well, you touched on quite a number of themes that we're going to deal with shortly: scope and equality of arms and matters of that kind. And I'm going to pass over to some of my colleagues. But Jana, do you want to say anything
yes.
in generality before that?
Could I add something very briefly, please, Chair? As a general observation, I'd like to make the point that we simply don't collect the data that we need in order to answer your question. We don't have the data at present to determine whether or not the Lord Chancellor is meeting his duty. So every quarter, as many of you will know, the Legal Aid Agency produces statistics around to show legal aid matter starts. I happen to produce a bulletin in relation to these, and it shows you the completed cases and the expenditure. So we know how many legal aid matters were opened, how many were closed, but we don't know how many matter starts were needed. There is currently no national measure of legal need out there. We also don't know the outcomes that were achieved through the legal aid scheme. And so a fundamental issue within the justice system, and this is something I'll be touching on throughout the course of my evidence this session, is that we don't collect the data that we need. There isn't a strategic approach to this data, which means that we aren't able to plan the services that we need adequately.
Is it collectible?
Absolutely.
Who should be doing it and how then?
We believe that this should be part of a national strategy around access to justice. So currently, forgive me, I don't want to segue too much, but currently we have the legal aid sector. We also have the legal support sector. We have the pro bono organisations. We have a whole host of other advice agencies, the free legal advice agencies, for example, and they are all doing absolutely brilliant work. It is a real privilege to be a part of this sector. However, they are all siloed. The data that they all collect isn't comparable. So we have no overarching picture of the justice system as a whole, and that's something that we desperately need. And to answer your question, Chair, we need that in order to assess whether or not the Lord Chancellor is currently meeting his obligations and responsibilities in relation to LASPO at a very start.
Okay, thank you very much. Some questions from Rangers.
To a large extent, you've already answered the questions that I was going to ask you, and I do welcome the comments that you've all made about what you consider to be access to justice. So with the present legal aid scheme that we've got, how does it affect the providers and the service users, and how does it impact early intervention and the cost to government?
I'll let you decide who goes first.
Well, I'll kick off on that. So at the moment, I think there are a number of issues with the system. The first is the scope. There's an awful lot of work that doesn't come within scope under LASPO. And what that means is that when you are seeing a client, you have to pigeonhole their different problems into things you can help them with and things you can't. Prior to LASPO, everything was in scope unless it was specifically excluded, and so you were able to deal with the client holistically. So I think it's been an extremely retrograde step that you can't now just deal with the problems that the person has. You have to pigeonhole everything and select which ones you deal with and which ones you have to send them off elsewhere for. So that's been really problematic. The means test is another major problem. The means test has not been uprated since 2010. So that means every year fewer and fewer people qualify financially for legal aid. Now, 3 years ago, the Ministry of Justice did a fantastic piece of work analysing the means test, analysing the data, and coming up with a revised scheme for how the means test should operate that was based on the Joseph Rowntree Foundation minimum income standards, so it had a real solid, rational underpinning. It was a brilliant piece of work that the Ministry did there, and it's not been implemented. They announced it in 2023, it was going to be implemented in 24. In 24, they announced that because of problems with the IT system and having to divert resources to deal with immigration legal aid following the Rwanda scheme, they didn't have the resources also to implement the means test, so we were told it would be 2026. We have repeatedly asked officials at the Ministry of Justice what is the current government's intention with regard to the means test, not least because the thresholds and allowances need to be uprated for inflation since the announcement. We have not been able to get an answer. We still do not know whether the previous government's announcement that this would be implemented in 2026 holds good, or whether there is going to be uprating of the thresholds and allowances. This means test is urgently in need of implementing. If, because of the IT data breach over the past few months or whatever, it still can't be implemented in full, we need the existing allowances to be uprated so that at least we bring more people into scope pending the full revamping of the scheme. But that is an urgent piece of work that should have been done years ago, but desperately needs to be done now. We've already touched on the issue of access to services and the fact that because of the remuneration rates being so low, the number of lawyers doing this work, the number of firms doing this work is dropping year on year. So even those Parliament has said should be entitled to legal aid very often struggle to get it. So there's a real difficulty for people. We've published a whole series of heat maps setting out the access problems across a number of categories of law. We're working on some revamped versions of those maps that should be published within the next few weeks. So hopefully we'll have some updated figures and illustrations there showing what the position is as at today. So there are huge problems there, even for those who Parliament has said should be entitled to legal aid. So all in all, the system is not remotely working as it should. There are problems across the board. We did some work on the remuneration rates. We commissioned Frontier Economics to analyse the situation. They looked in detail at housing and family legal aid. In housing, they found that 100% of their sample was loss-making, and that was even allowing for when they were able to get inter partes costs on civil cases that they won against the other side and got the costs back at private rates. They were still loss-making, even allowing for that. In family, it was something like 50% of firms, more than 50%, were loss-making. Those who were doing private law work, so dealing with domestic violence cases, were almost universally loss-making. Those who were doing care proceedings, they were more likely to be at least breaking even. But even there, it was marginal, and if the rates are not increased soon, they will also all be loss-making. Family rates have not increased since 1996, and in fact they have been cut in the interim. That is what we're talking about here. That's why this does not make economic sense for firms to do this work, and that has to be addressed.
Before others come in, I may be wrong in thinking this, but my understanding is that private family law cases are not included unless they involve an element of domestic violence.
That's correct, yes.
So how does that affect those cases, those private family law cases, where they just cannot get legal aid?
What we're seeing there more and more often is that the people will go to court as litigants in person, and that brings in a whole host of additional problems. So first of all, they're having to navigate these systems themselves without assistance, and some of them really struggle to do so. It has a real impact on the courts, because what we have seen is that litigants in person are more likely to go to court rather than trying to resolve things through mediation and negotiation. Hearings are likely to take longer because the judge has to spend more time explaining to them what's needed and what everything means. and the cases are more likely to go to a fully contested final hearing because the parties simply don't know what a reasonable settlement looks like and therefore don't know what they should or shouldn't accept. So it has quite a significant burden on court time. Now, there's a problem with the official statistics in relation to the impact of litigants in person on the courts, because those stats lump together those cases where the party is taking no part in the proceedings whatsoever, so everything goes through by default. They're treated as a litigant in person, as are those who are actively trying to just manoeuvre their way through the court system. And so when you average out those two classes of client, of course the average looks the same as for represented parties, but for those who are actively trying to fight their way through the system, the impact on the courts is significant. Any judge who has ever had a litigant in person before them will tell you the same thing. It takes a lot longer, it's a lot more difficult. And just on top of that as well, we have the added point that in those cases where there are allegations of abuse and the alleged abuser is not represented, this leads to them having to cross-examine the alleged victim in person. We have brought in a scheme to try and prevent that from happening. It's called Qualified Legal Representatives. And unfortunately, that scheme simply isn't working at the moment. The government brought it in on the basis that they would pay these qualified legal representatives at legal aid rates, and they simply couldn't find enough lawyers willing to do it at that rate for it to operate effectively. Even with the increase in rates that they have made, it's still not attracting enough lawyers to do this. So you have this situation where effectively judges are looking at the case and saying, we need a qualified legal representative, we can't get one, and so they're having to find workarounds as to how they deal with that. But the whole qualified legal representative scheme costs money that could be put into actually providing proper legal aid for people, and it's not working either.
May I jump in with something? Because in preparation for today's evidence session, I spoke with a number of our members and some of their clients, and one particularly memorable story that I heard goes to this very point. So this involved a young mother whose marriage was breaking down around allegations of sexual abuse with her ex-husband as the alleged perpetrator, and the abuse being perpetrated against her young son, who was 5 years old. So she was holding down two jobs. She was working part-time, managing the childcare arrangements for herself, and she was earning £18,000. Under the current financial thresholds of the means test, which is still in place, she was deemed to be ineligible for legal aid. She faced her ex-husband, so the alleged perpetrator of sexual abuse towards her young child, in court. He had a full team of legal advisors. She spoke to me about having to Google terms in relation to the court proceedings on her phone under the desk throughout the proceedings because she couldn't understand what was happening. I can't even begin to imagine how emotive and horrendous that must have been, but that is the reality that a number of our clients are facing. I also spoke to someone else who had been deemed ineligible for legal aid under the current means threshold. She was incredibly disabled and needed some urgent adjustments to be made to her housing in order to make it habitable. She was £4.50 over the threshold and she was deemed to be ineligible. One of our member firms took the case on a pro bono basis. Now, what we have to remember is that for every client who is helped on a pro bono basis by lawyers, there are thousands, if not hundreds of thousands of people who aren't and who don't have access to that advice and representation. And I wanted to flesh out what Richard was saying in relation to the means test. Sorry, we've covered so much ground in just 5 minutes.
I'm impressed.
But I wanted to flesh out with some numbers because I find some of these numbers absolutely staggering. And the research that the Law Society undertook together with Professor Hirsch showed that in order to be fully eligible for legal aid, as it currently stands, a single person needs to be surviving on just £9 a day after housing and general living expenses. £9. That's pretty much the cost of a coffee and a sandwich at any number of high street shops or coffee shops that you may have passed on your way in today. I find that absolutely staggering. For families with 2 children, they have to be surviving on £41 a day. So we're talking about sort of 81% below the minimum income standard in order for that recognition to apply and for you to be eligible for legal aid as things currently stand. So we, together with the Law Society, urge government to implement these changes urgently. But also I'd like to make the point that we shouldn't have let it go for so long. So the thresholds were last increased in 2009, and the means test review was undertaken in 2022. A huge amount of inflation occurred in that period of time. I'm going to be talking about inflation later on when we discuss fees more generally. But there is absolutely no way that we should be allowing that much time to pass, given the skyrocketing rates of inflation that we're all seeing, before a review is undertaken. So as part of the national strategy, we need to be making sure that our mechanisms are uprated on a regular basis so that we never have these issues again.
I'm going to come in very quickly so I don't repeat. The Bar Council's position absolutely agrees with everything that has been said. Really focusing it down, the means testing, it is so low. It needs to be increased to provide meaningful access to justice. It simply doesn't provide meaningful access to justice currently. We also have looked at early legal advice, and there was a report between the Bar Council with the Access to Justice Foundation, and that details the economic value of free legal advice and the free legal advice sector. And a key stat from that is that for every £1 the Treasury spends on legal advice, it saves the public purse £2.71. So it's nearly threefold saving on the investment. The domestic violence, it's a really important issue, and the Bar Council's position is that there should be full eligibility to legal aid for those who are complaining or alleging domestic abuse, and so the current restrictions should be lifted. The QLR issue has been raised. The Bar Council issued a report which has had input from, I think it's around 100 family law barristers, and it was issued just before Christmas. That addresses QLR and the lack of them. It addresses the reasons why, and it also points very strongly at the issue of retention of family law barristers, because there hasn't been any increase for legal aid for them since 1996. So there's issues across the family bar sphere. It's not always as prominent, perhaps, because of the way the proceedings take place. They take place in private. So it seems to have lacked that oxygen. However, there is a focus on violence against women and girls, and much of those cases are dealt with in the family court, and their barristers are needed to represent and to ensure that those cases are heard properly. So the to answer your question, it's very, very, very important, and it's completely failing currently. I think for just to add to the information, there has been one uplift announcement which was on the 1st of December 25, and that was in relation to housing and immigration legal aid fees. That is the first major civil legal aid fee increase since 96, and it's 18 million a year. When it's going to come in, I'm not sure. It's a very small amount of money in relation to need. I also agree with the point on data, identifying exactly what that need is. And if you have the data, then you are going to have solid statistics to bring within LASPO, those that are currently out of scope as well.
Thank you very much. We are covering a lot of ground very quickly. I'd say, I'm sure unnecessarily, to the witnesses, there's no need to repeat what's been said, and to the members of the committee, there's no need to ask questions that have already been asked. I want to bring Ashley in a moment. Rohini, did you have any other questions?
Yeah, two very quick questions, but following on from what you said, I would be correct in thinking what you said, Mr. Miller, about the number of litigants in person and the delays that incurs with judges having to take extra time in helping them. If they had proper legal representation, it would take less time to deal with those cases, So ultimately it would help in reducing the delays in the court system and also save cost in the long run as well. I would be correct in thinking that.
Yes.
So just very 2 quick points. Have you looked at any other jurisdictions, and do we have something to learn from the way that their legal aid systems work?
We have looked at a number of other jurisdictions, one in particular that we focused on recently. The Netherlands runs what they call the high trust model. And we also think there are lessons that could be learnt from the contingency arrangements that were brought in following the data breach. So a lot more had to be delegated down to firms. And so what that means is, rather than government officials taking decisions at various stages through every individual case, a lot of that decision making was delegated to the professionals who are representing those clients and who know the case, know what's needed, and have the professional judgment to decide how things should be taken forward. And that level of high trust of your expert providers who are running the cases, I think has the scope to significantly reduce the bureaucracy, which would help with the economic case for doing legal aid, and also to speed cases up, so it would enable the firms to provide advice more swiftly and to progress cases quickly without having to keep going back to the government agency and wait for decisions. So I think there is a lot that could be learnt there in terms of better, more efficient, more cost-effective ways of running the system. I think the current approach is a rather penny-wise and pound-foolish, frankly.
If I can just add, if it helps on the family court statistics with litigants in person, in 2024 there were 21,356 private family law cases where both parties were unrepresented. That makes up 46% of all disposals in private family law. To compare, 10-year comparison, in 2014, there were 13,107 private family law cases where both parties were unrepresented, making up 33% of all disposals in private family law cases. So those stats you can look in more detail, and we can always send them through, but they come from the MOJ. Adding to that, with just touching on family, but also looking at the High Court and your question on litigants in person, one other issue there with looking at backlogs and time of the court being used is you also will have a litigant person who's simply in the wrong jurisdiction. They are trying to take a judicial review case where, in fact, they should be sorting out their street homelessness in the county court. We also have anecdotal evidence, and you'll be better to help on this than I can, of MPs in particular still getting lots of constituents with issues with immigration and housing. So that demand is high. Legal aid is really not there. Or it might be there for those who are on income support. So legal aid is cutting out the working person. If you've got legal aid for those on income support, you've then got this issue with capacity of lawyers to represent because of the rates that are being paid to lawyers. So you've kind of got all these sort of double edges around it. You litigant in person, there's plenty of street homeless cases, for example, that end up in the High Court. They are eligible for legal aid. They are eligible for legal advice. Why don't they have a lawyer? And that can only be because there's no capacity left for lawyers to take those cases. So give you an example. I've seen it, my experience. There's a case, street homeless or a homelessness case, and the litigant in person is literally there with their sleeping bag saying, I'm camping outside my council office. They know all about me. You've got the local authority on the other side with the lawyer saying, there's no unlawful public law matter here to be determined. And then the judge will spend a good hour, 2 hours trying to go through, sometimes with the litigant in person, explain, sometimes sending out the lawyer. Can you contact the person in charge of housing with this particular, it's cold, they're sleeping on the streets, etc. It takes a huge amount of time, and that is the lack of that advice and lack of funding, which it comes back to. I don't know if that helps, but just to give you, perhaps bring it to life a little in civil as well as in family.
Can
Sorry,
can I just return to that point around the Borg point? So since LASPO, there's been a 340% increase in unrepresented parties seeking protective injunctions specifically. So to the government's mission around reducing violence against women and girls, this has to form a core component of that. We do need to build up capacity within the family courts and to address some of the deficits that we're currently seeing with capacity, with funding, with family firms being willing and able to take on cases in this area.
Regarding the next question, Ms. Brimelow, you've already confirmed that as regards exceptional case funding, that scheme is not effective in securing access to justice, so I'll just take that as an answer, unless you've got anything else to say.
There's a little bit to
expand
on that, to be honest.
I was going to ask if I could
you.
just add a little from the solicitor's point of view.
Yes.
So the idea of exceptional case funding was that for all the cases that are coming out of scope under LASPO, there would be this safety net that if the case nonetheless gave rise to a human rights issue, that there would be this protection. It has been estimated to take anything 4-6 hours to complete an application for exceptional case funding, and that's with no guarantee that you will actually get the funding in the end. We are in fact seeing pro bono lawyers sometimes assisting a client to apply for exceptional case funding, and the legal aid agency taking the application not on the basis that there is a solicitor there taking on the case, but on behalf of the client to say, yes, we will grant exceptional case funding, with the idea that they would then go and find a lawyer who would take on the case. But what we're finding is very often, even in cases where the LAA has in principle granted the exceptional case funding, the clients can't find a lawyer who will take it on. Because these are areas that usually aren't within the scope of legal aid, and therefore the lawyers who have the expertise in those areas just aren't interested in taking those cases on. So the combination of the time and the cost of putting in an application in the first place and the difficulty of finding a lawyer with the right expertise for those cases means the system really is not working effectively.
Those 6 hours are not remunerated.
Exactly.
So from a number perspective, as Mr. Miller mentioned, this was intended as a safety net and to protect sort of in those cases, because so much was taken out of scope with LASPO. The intention was to protect those human rights cases and cases involving rights under the ECHR and then the EU as well. And during the passage of the bill, the government anticipated that there would be between 5,000 to 7,000 applications made annually. In the first year, there were about 1,520 applications that were made, of which just 4.5% of them were granted. Now, those numbers have gone up, but given that this was originally intended to be a safety net, I think the numbers demonstrate that it simply isn't acting the way that we all anticipated that it would. It's too complex for individuals to complete the application process by themselves. And providers, you will hear a lot of evidence, and you will have read a lot of evidence in preparation for this particular inquiry around the financial viability of legal aid firms. With profit margins so very, very low, there simply isn't the appetite within the sector to take on this work, which is at risk. It's just too risky for providers to do.
Can I add on the risk? This is the cost risk, which I referred to in the opening, which is really important, that advising a client to go ahead when the position is, unless there's a personal injury included in that claim, that human rights claim, that claim against the state, if they lose, they will be liable for the costs. That is a huge risk for somebody who's got some basic means that they're not prepared to take. And in fact, you do see with the figures on civil work that it's something like it's been reduced by, I think it's been reduced by something like 3/4 of, I can get the exact figure, but something like 3/4 of cases. There's been reduction post-LASPO of claims being brought. And that is a reflection on both the funding but also very much the cost risk. And that was addressed by the Jackson Review and was not followed. And it's very, very significant.
Thank you so much.
Thank you very much. Sashi Fox.
Mr. Miller, can I bring you back to the cost of the updated means test? You said the Ministry of Justice did some work and came up with a scheme in 2022. If that had been introduced, what would have been the cost to the taxpayer? Have you any idea?
I can't remember the exact cost. I know the Ministry at the time did put together some figures that showed what the cost would be. I know that in terms of the number of people they said would be brought within the scope, it was something like 3.5 million more people would be within scope for criminal legal aid and about 2.5 million for civil legal aid. But obviously that's across the country, the number of people who would be theoretically eligible.
Tens of millions of pounds, I assume.
I don't think it was many tens of millions. I think it was... best recollection is it was sort of low tens of millions. And I think one of the things...
Do you have a figure for me or not?
The point that I wanted to make to you was it depends how you calculate that cost. So are we talking about the cost of the Ministry of Justice?
Yes.
Or are we actually allowing for the fact that there are lots of, when people don't get legal advice or representation, there are lots of knock-on effects. We are essentially, legal aid as it is currently is managing crisis. If legal aid and legal advice or representation is provided at an earlier point, which was the theory behind the means tested review, the knock-on effects to other departments such as the NHS, Department of Education, for example, will be less. So how would you like us to calculate that cost?
Well, assuming the budget cost to the Ministry of Justice.
To the Ministry of Justice.
But we don't have a figure.
We don't have a figure.
Fair enough.
The figure exists and was published by the MOJ at the time, but I can't remember offhand what it was.
We could supply that information.
You see, Mr Miller, you're here on behalf of the Law Society, Miss Brimelow on behalf of the Bar Council, and effectively as the trades unions of the legal profession, I don't blame you for advocating for a lot more money to be spent on legal services. That's your job. But I don't detect any appetite on behalf of taxpayers for spending more money on lawyers. And I certainly don't see legal aid being treated like the NHS, which I think is a rather fanciful wish, if you don't mind me saying. I just wondered, do you have any recommendations for us to improve access for justice that don't involve very large amounts of taxpayers' money?
Well, first of all, it doesn't involve very large amounts of taxpayers' money. I mean, this is the point. The figures we're talking about are often rounding up figures in terms of a treasury, looking at treasury spending. Or they are slightly more than that. We're talking about tens of millions. We're not talking about very large amounts. Secondly, I do push back slightly on the description of it all being about lawyers and money. It really isn't. And the Bar Council, of course, we're the voice of the profession. We're looking at retaining barristers and retaining barristers to carry out part of what is required in a liberal democracy, which is a strong rule of law. So contributing to that. So the principle is very important to barristers, and particularly if you work in legal aid, because frankly, if you were up for making lots of money, you would not be working legal aid in the first place, because a huge amount of that involves working pro bono and very, very long hours. And you are driven by the justice of the person that you are representing. So I don't recognise that description at all of any of my legal aid colleagues. The reason it has to be, we can't step around it. I'll come on to your question on other suggestions. We can't step around it is because it really is at the core of the system functioning properly. So any court, if the roof is coming in, if the IT doesn't work, if you've got a litigant in person who needs huge amounts of help, if the court staff are spending huge amounts of time trying to put a bundle together for the litigant in person, if the person is traumatised about going to court because they know they're going to be questioned by somebody they're accusing of abusing them. I mean, all of this shows that the system needs money. Now, that, and I don't shy away from, that money should also be paying the barristers who are helping that justice be delivered. So that can't be taken away. How do you persuade, an answer to your question? I don't see it as fanciful that it should be seen as part of the NHS. The reason it isn't is because people don't always need lawyers. And so therefore they will think, well, I'm not going to need one. But in fact, and therefore I don't care about all those people who do. But the reality is more people need lawyers than you think. It's just that they have the money to pay for them privately. So you are therefore really causing a two-tier in terms of who has access to justice. And that's what this whole discussion is about. How do you persuade outside money? There's lots that can be done outside money, which includes looking at efficiencies within the system. But that does come back to, well, why is that inefficient? And quite often it comes back to wasted investment or investment in the wrong areas. So it does really come back to that. Certainly with crime, efficiencies are really key. We see lots of waste of money that goes to the Ministry of Justice because it's going in the wrong area, sometimes on the wrong tech. We see lots of waste on contracts. I can give PEC's contract as an example, where they don't get people to court on time, in the dock on time, so there's more wasted money. So you've lots you can do around that, but I'd really keep the focus back. I know this session is back on legal aid, and it's important. And I'd really would hope we can persuade Parliament and the job that you do, how key it is, because it's almost one of those areas that until it's not there that you don't always appreciate it. And when people hit a point where they've got a loved one who's suddenly been in a terrible accident or something happens or an illness develops and they find themselves in this position where they need legal advice, and they're a working family but they're not on income support, and they find that they've nowhere to go and no barristers or lawyers to represent them, then it's brought into sharp focus. So it's really looking at the overview before we have to look at each case individually. But so it goes back to principle, lots of efficiencies, but let's not shy away from the money. It's really not that much, and the investment repays as well, in that it causes savings in the long run.
Yeah, I think one of the things that I would reflect on is when Mr Bates v the Post Office was broadcast, there was an outcry across the country about the injustice that had been done to those postmasters. The country does care about justice, and when it's brought into sharp focus like that, they care deeply that justice must be done. So I don't think it's a forlorn hope to say that the country will recognise that actually justice is important. And I also reflect on, with the Hillsborough bill, what we're seeing there is we want to provide legal aid for the families. Publicly funded lawyers are already provided for every state body that's ever involved in these cases at a vastly higher rate, perhaps 10 times the rate that is paid to legal aid lawyers. So if there is a concern about taxpayers' money being spent on publicly funded lawyers, surely that's where we should be focusing, not on legal aid, where we're finally actually giving ordinary people the chance to get the justice that they need.
And, sorry, can I come back to Sir Ashley as well?
If you could try and answer the question, that would be appreciated.
I fundamentally disagree that people don't care about justice. Today we have been...
The question was, do you have any recommendations for improving access to justice that don't involve large amounts of taxpayers' money?
I do. A national strategy which actually looks at justice as an entire concept would be one of them, and collecting the correct data so that we could best use our resources to help the most people would be one. But I wanted to say that I disagree with the fact that people don't care about justice. We are talking about justice with a large J, a capital J, as it were, this afternoon. Actually, when you boil it down to its fundamentals, people do care about justice with a small j. They care about their housing. They care about their children's education. They care about their employment. They care about the community care that their elderly mother is receiving. These are all justice issues. What we're talking about today underpins all of them. And I couldn't agree more with Mr. Miller's point. We are seemingly accepting of large amounts of money being used to pay and prop up the state in relation to justice issues. And we should be more comfortable with redressing that balance so that ordinary people have the access to justice that they need and that I do believe that they care about.
I think ultimately what it comes down to is it's far more expensive to run the system from crisis to crisis than it is to fund it properly, to run effectively. If you provide the early advice, you don't end up with huge expensive disputes. If you enable someone to resolve their social welfare issues at a relatively early stage, they don't run into health problems because of the stress on them, because of the mould in their homes, because of all of these other issues that are weighing down on them. the savings to the health service, to the rest of the justice system, to the prison system, if we stop people going into the criminal justice system, there are huge savings if we just fund the system effectively to run as it's supposed to do. Running it crisis to crisis is hugely expensive.
Yeah, I agree with that. I'm coming back to your question, Sir Ashley, on it's that point of what happens on. You've got somebody with a grievance, with a complaint. It's that flashpoint. Now, can you divert it in some way through alternative dispute resolution? And how can that be done? Because it can increase, and then you get sides which become polarised and entrenched, and you can end up in litigation, and not everything needs to end up in litigation. So I certainly would encourage more mediation, ADR. On the criminal side, there's lots of representations or proposals from the Gork Review which are coming through in the sentencing bill, and they also are recommendations on diversion. So again, just because it's not an academic exercise, is there potentially a crime here? Is in fact this in the public interest to prosecute it? And often it's not, and particularly when the years that go by, divert out and actually address often it's you've got lots of sort of social breakdown, and often you might have addiction issues and so on, where some treatment would actually save the money into which is going into prosecution and all that entails. So the diversion away would be a good focus also.
I'm going to move things on. I'm conscious that we're halfway through our time and a quarter of the way through our questions, which shows that my chairing skills haven't improved over Christmas. We are going to Lindsay Farnsworth in a moment, but I've got two short interventions from Pam Cox and Neil Shastri-Hurst. So Pam.
Thank you. I want to take you back to this idea of a national strategy around legal aid, and some of the foundational legislation that set up our current system was passed in the wake of the Second World War, alongside the setting up of the NHS and now other services, so it fitted very much in that way of thinking at that time. The legal aid sector is very fragmented, as you said. Which agencies do you think would be best placed to lead such a strategy, given the fragmentation, and what role could the legal profession take in leading such a strategy?
You currently have a sector which is incredibly committed to the idea of justice. So legal aid professionals undertake hours, if not days, if not weeks, of unpaid work together with the Ministry of Justice to try and improve the system. So I have no doubt that they are very committed to this idea, but I think this needs to be taken forward by the government. And we need to be approaching justice far more strategically than we are at present. To return to Sir Ashley's question earlier, we could better spend money if we knew exactly, if we had the data that sat behind the initiatives that we want to implement, if we had an idea of what initiatives work best with particular demographics, if the funding was more centralised so that everyone knew exactly how much funding they could expect moving forwards, it would just enable a much cleaner, better system, which was more able to cope with sudden crises. So during COVID, the legal aid sector suffered immeasurably. And if that was contained within an entire system, and we'd adopted a more strategic approach to the delivery of justice, we could have had contingency measures in place. And we'll touch upon that presumably when we speak around the LAA data breach that we saw earlier this year as well. But to answer your question, I do believe it needs to be a government initiative and driven forward by the state with support from the profession.
Can I add that we really wouldn't want another full inquiry, because there are so many independent reviews which themselves cost lots of money. So we actually have all the information. What we clearly need is multi-year agreements between on legal aid between the professions and the Ministry of Justice. It feels like the legal professionals are constantly locked into negotiations with the Ministry of Justice, and as Richard Miller has said, it's because there's crises which are just increasing. On crime, there's been I'm not going to go into it in detail, but there's been an additional 34 million, for example, announced for criminal advocacy. Detail on that is is 0 currently. It will all take time and so on. But if there was an index linking or a pay review type body, that would save this constant back and forth and the energy and the time and the expense that it is taking each time. So we have sufficient data. We know what inflation is. We know what reasonable rates are. We can compare to what the government pays its lawyers when they are on the opposite side on the cases as a reasonable starting point. And it really is taking the argument to Treasury if the position is that there is a will and a political will for there to be access to justice as was set up, and it really will involve a change around LASPO, increase in criminal legal aid, increase in family legal aid. It just simply can't remain frozen as it has. So I agree. I would say we just simply don't want more and more reviews, but we can build on what we have. But let's stop this constant crisis evidence collecting in this way. It'd be so nice to have one of these evidence sessions where we can be then focusing perhaps on the people exactly under the legal aid, in that's all running and people are being paid what they're being paid. And it's all index linked, and we're not dealing with inflation and so on and so forth.
Just one point to add, which is I think there's a number of different government departments that are relevant here. So you've got ombudsman services that will relate to the department for the sector that they operate in. You've got pro bono is overseen largely in the Attorney General's office. You've got local authorities provide a lot of funding for advice services locally across the country as well. But I think it's the Ministry of Justice that needs to lead on this. But they do need to reach out and engage with all of these other departments that have a stake in the whole justice dispute resolution system.
Yeah.
Very quickly, and you may not have the details in front of you, but you're all making a very compelling case for more legal aid funding in order to have a long-term benefit and reduce costs across the board. What I haven't got a handle at yet is whether there's been any concrete modelling in how increasing at the front end that legal aid funding would improve or reduce costs across the board in a variety of areas. Has that modelling taken place? And if it has, can you share that with the committee, either in summary now or perhaps writing back to the committee afterwards?
This has long been one of the real challenging issues. It's the holy grail for academic research into access to justice. There have been numerous studies over the past 20 years looking at what is the cost benefit of providing early advice. Every single one of those studies has shown that there is a substantial return from the investment. However, it's also fair to say that every one of those studies does have methodological problems to them. The real challenge is you can't measure the counterfactual. You can't measure what would have happened if this individual hadn't got advice. Well, they would have gone down this path instead. You can't do that for one individual, let alone to say what it would look like across a whole cohort of individuals. So it's really challenging to come up with a hard, concrete, reliable figure for what is the saving that you get from that investment that you've put in. What I would say is I think if you look back over the history of the past 20 years or so, with the reduced investment in access to justice, we have seen costs increase in a number of other areas that indicate the mechanisms that operate, but putting hard figures on it is a real challenge, and it's something that no one we've spoken to has yet been able to crack.
Not least because the fee schemes that we're talking about are wildly complicated and differ from practice area to practice area. So there is that additional complexity. And numerous people have tried, but we don't have an adequate model at this time.
And is part of that underpinned by the fact that, as you've said earlier on, there isn't sufficient data across the board? Exactly that.
And the data that we have, there's a lack of interoperability amongst the data that we have. Different organisations are collecting data in different ways.
So to a degree, we're doing things anecdotally here.
We're doing things in an incredibly piecemeal way. To your point about efficiencies, this is not an efficient or strategic way of doing things.
The report with the Access to Justice Foundation and the Bar Council does address as much as it can on the data, the savings. And I refer to one figure, there was a 3 times increase potentially in terms of expense if that early legal advice hadn't happened. So that we can certainly send that across. That does what it can. But I agree that there's difficulties because there's so many what's ifs. So I agree what's also been said. It does come down to data.
I'm very sorry, Chair. Can I just jump in with one extra point? It's around the Green Book and Treasury rules for how we measure sort of social value and cost benefit. And while there seems to be sort of a push by Treasury to measure social value across departmentally, we're not seeing that at the Ministry of Justice. So it's very hard to demonstrate the actual cost of a particular model because the knock-on effects and the knock-on benefits will be felt by other departments, and we have no way of quantifying those at present.
Okay, let's move on. I'm going to Lindsay Farnsworth next. I think what I will have to do, in the interest of time, is to say, and the questioners can specify this, the question will have to be to one person who's most appropriate to answer the question, or we're simply not going to get through. Lindsay.
I'm going to ask Rohini, Jana, the following question regarding the Public Office Accountability Bill, or the Hillsborough Law, although obviously not solely related just to football incidences. We've talked about the new law and impact on access to justice in terms of equality of arms and the suggestion of a need to rebalance remuneration based on who the lawyer is representing. I think state bodies and families, so I don't really want to go over that again in the interests of time, but I just wondered whether you felt that there were any key limitations to the expansion of this of legal aid in this area, and what are the further changes you may propose to strengthen it.
Thank you very much. That's a really important question. It's very rare that in legal aid that we get good news stories, and it's been wonderful to be able to celebrate Hillsborough and the expansion to civil legal aid that it represents, and fantastic for all the families that have campaigned so long and so hard for it. We are aware that this position is constantly evolving, so please take my comments on that basis. But we are also aware that there is a potential capacity issue within the sector. It's been 30 years since civil legal aid last received an uplift in most areas. And while we are incredibly excited from the perspective of equality of arms and families who have been through unimaginable loss, having access to representation in this way, there remains a concern within the sector that there may not be the capacity within the sector to meet that demand. There are any number of meetings going on between the MOJ, various representative bodies, ourselves included, the Law Society, the Bar Council, etc., around this. So, as I said before, this is a constantly evolving position, but every single legal aid practitioner who practices in inquest is citing remuneration as being a significant area of concern for why they wouldn't necessarily rush to do this work, despite the fact that they all believe in it passionately. It is essentially loss-making, and hugely emotive. We don't know currently how many inquest lawyers there are out there at the moment. And again, this goes back to the point that we just can't, there is so much that we can't measure within the justice system, and that need underpinning it all for better data. We are aware that we have rough numbers around the number of public lawyers that there are who may be interested in starting this work and retraining. But then there remains concerns that they may be sort of we may lose capacity in other areas of public law and civil legal aid if they all sort of rush to do inquest work. So these are concerns that we are worried about. And another point that I wanted to make in relation to this was the interested person funding gap that's currently being sort of envisaged. So there's a friction point with the bill as currently envisaged, whereby funding is only triggered once a public body is formally named as an interested person. Now, the APPG on Access to Justice ran a Hillsborough meeting a few weeks ago, which some of you very kindly attended, and we had a number of practitioners making the point that actually this could take months, if not years, for a public body to be named as an interested person. So that's another little wrinkle that we will need to iron out as the bill progresses through Parliament.
Thank you. Very useful. I'd like to move on. As a former prosecutor, hopefully you won't be too surprised that I want to just focus a little bit of our time on criminal legal aid. And maybe I could start, I will come to you, Kirsty Brimelow, I promise, but I wonder if I could start by asking Richard Miller a question in relation to the criminal duty solicitor scheme at police stations and in the court. I did qualify for as a lawyer in those two schemes some 20 years ago, and it was under pressure then. So I'm quite interested to learn more about what the current state of those schemes are, please, and whether they're sustainable given the workforce pressures that we've already been talking about in the wider justice system.
Yeah, the current situation is, no, those schemes are not sustainable. The numbers are dropping. There are growing numbers of duty solicitor schemes where there are fewer than 7 duty solicitors on the scheme, which means that each one must be on duty for at least one 24-hour period every single week. The burnout rate for those who are left on these schemes is getting worse. The average age of duty solicitors now is about 51. 47% of them are over the age of 50, and only 7% are under the age of 35. So it's very much an ageing profession. In fact, I would go further. I would say it's a profession that's going extinct before our very eyes. Now, the increase in rates from the Ministry of Justice recently has been very welcome. It means that at long last, the government has implemented Bellamy in cash terms. However, by the end of this Parliament, in real terms, we are going to be back to where we were before Bellamy reported and said this system is completely unsustainable, it's seriously loss-making, and it urgently needs significant investment if it's going to survive in the longer term. So the fact that we are not seeing a commitment to a regular increase, I think, is fatal to the system surviving more than a very short time. If firms are going to see a business proposition for carrying on doing this work, they need to know as an absolute baseline these rates are going to be maintained in real terms. We still need to build beyond that to rebuild the capacity that we've lost, but unless we get as an absolute minimum the commitment to keep rates in real terms where they are, there is no hope for the system.
That's really worrying about the age. It was always the younger solicitors that were sent out from my firm.
Right. It used to be the way, very much so, yes. Yeah.
Well, thank you for outlining that. It's really useful. Kirsty Brimelow, if I could ask you a couple of questions on this area. Given the need for timely legal advice, both to protect criminal defendants' rights and also allow the police to do their jobs, what impact does this have, the sorts of things that Richard has been talking about? What impact on access to justice does it have in your experience?
Yeah, so this is particularly with the junior bar and the instruction of the junior bar that is a real ongoing concern. The solicitors will be the first port of call for the person who's detained, and then they will instruct the barrister. And if there aren't sufficient junior barristers, then we're having an issue of representation. And what happens in practice is that cases are adjourned, so they go back because there aren't sufficient barristers there actually to represent the client or to prosecute. So we have both sides where cases are put back, adjourned, because there aren't sufficient lawyers. Again, it comes back to funding, although we have probably a reasonable uptick now of juniors coming to the criminal bar certainly post the last statistics, post 2022, retention remains an issue. And at the senior end, with the KC end, retention is a huge issue, that the KCs are leaving by a pretty high percentage, actually, something like 25%. Are leaving doing criminal work to go into other areas. The funding, just very briefly, the MOJ's had deeper cuts than any other department. The overall the funding for justice is 30.4% below where it would have been if it had kept pace with the UK's inflation, population growth and economy. Other figures, just cuts, it's declined by 22.4% per person terms between 2009-10 to 2022-23. Effects it has, access to justice, representing those who are in jeopardy of detention. I mean, it's one of the probably the most serious violations of rights that happen in the Crown Court. Right to life is in there, and right to liberty is in there. And this is where it's really key that you have barristers there who can act for both sides. And the announcement on an increase in legal aid needs to be brought in quickly, but importantly, it needs to be brought in on the backlog cases. The difficulty is that the way the system's always been set up is it's forward-looking. Now, because of the delays we have, to say that you will get an increase in legal aid in 2-3 years' time when that case comes through the backlog is not an increase at all. So it has to be on the cases that barristers are doing now in court, and that means it's got to be retrospective if you want to use that, but it's just current. So that is a really big issue that needs to be taken up. When there are deals, unfortunately, they have consistently fallen short. So this is MOJ modelling, and we're hopeful that the last deal that happened where there was a shortfall is going to be rectified by the MOJ. We're in discussions there. If I just add very briefly on Hillsborough, it's welcome that there's that expansion and absolutely fantastic work by all those involved, and very moving to see. In fact, I know it comes back to the amount of the ECG. Doughty Street Chambers have given as an example, does most of this type of work, and there's real concern that there just won't be enough barristers to take that wonderful success forward unless the ECG payments are increased.
Thank you. And that's very, very helpful, thank you. Just going back to the criminal side of things, restricting early legal advice because of the sorts of issues that we've talked about, what's the knock-on practical consequence to the functioning of the criminal court system as a result of that?
It's a really good question, because in fact, if you have early legal advice that is done, but it has to be done properly, where the cases, the evidence relied upon is also served by the prosecution. So everything needs to speed up and to be done properly. That then cuts out the delays. If there is evidence there, here's the forensic evidence of somebody's footprint or DNA. It's very different advice to if there's no evidence there in relation to that, and the client is there saying, I didn't do anything. So, well, here's a fingerprint. What happened then, and then things might start to change. So it makes a big difference as to what happens to the case and what it looks like. Early legal advice as well can really be effective in making representations to the prosecution. Is this a case that should be prosecuted at that level? Is this not a case that can be diverted away from the court system? Or, in fact, it might be a case where a plea to a lesser charge could be offered. We're losing all of that because of the delays. Everything waits until evidence comes much further down the line. And there's not, I would say, and certainly from conversations with the membership of barristers up and down the country, there's just not enough of a strong triaging by the Crown Prosecution Service of cases. Just because you can prosecute an offence at that level doesn't mean it's in the public interest that you do. And can we go back perhaps to also listening to advice from barristers who are prosecuting in court, who would be recommending that it's a lesser charge, and that somebody's at the end of the phone can make that decision and say, yes, that is acceptable, obviously after consulting with the victims. And that all seems to have dropped out of the system as well. So that early advice is really key.
Thank you.
Thank you very much. We've dealt to some extent with means testing already, so I won't go to Pam. Vicky, did you want to come in on?
Yeah, if you don't mind, I'm sorry to go back to it, but I'm concerned, particularly with some things that you said, Rohini, about access to justice for people who are working versus people who are on universal credit. And I know Lindsay and I have both discussed a couple of cases that we've had where there has been custody and allegations of domestic abuse, where the women have been working, the men involved have been claiming benefits, the men have been able to claim full legal aid, the women have had to turn to their families who've got into debt, and there doesn't seem to be, from the experience that I've had with the cases I've dealt with, much rigour in terms of establishing whether someone should be given universal credit, should be given legal aid based on the fact they have universal credit, and whether the system is being manipulated. So I'm interested, with that sort of background, we know that there's passporting happens with some benefits. I'm wondering if you can share your thoughts on the benefits to providers and the government. We know what the benefits are to the individuals of those benefits being passportable, and what the consequences would be in terms of access to justice if they weren't, whether there's any advice or recommendations you could give about how that arrangement could be shifted so that it feels fairer to everyone.
Absolutely. So we would absolutely recommend that those who are in receipt of universal credit be automatically deemed to be in financial need in relation for the purposes of the means test. From a provider perspective, that would save a huge amount of time that providers currently spend checking financial eligibility against the means threshold. That's unbillable time for providers. If we could speed that process up, if providers didn't have to do that, it would make both practices a little bit more financially viable. Just as a slight segue, LAPG recently conducted some research into unbillable tasks. Eligibility was one of them, and testing eligibility for the purposes of the means threshold. Providers on average spend almost 2 hours or a quarter of their working day on unbillable tasks. If you were to reduce that, that would automatically make legal aid practice far more financially viable than it currently is. One thing that we haven't addressed today is the perception of justice. And I think in those instances, what's very striking to me is that those clients, those individuals that you are helping through your constituency services, there is no way that they are going to perceive that they are receiving justice in this particular equation. There's no way that, to go back to the Chair's very first question around access to justice, the client who was sat there Googling terms in family proceedings, trying to understand what was going on, there's no way that anyone in this room could argue that that was access to justice that she was receiving. So yes, to your point, I think there are benefits both for the individual, the client, and for the provider in passporting universal credit automatically and removing some of those additional administrative barriers, but also just having a rethink about how this system should be working and what we want. Again, I'm very sorry to harp on about this point, but I do think that we need to take a more strategic approach to access to justice. What would be fair in those circumstances? And let's apply that. What do we need in order to make that? What is the legal need here, and how do we address it and best meet it?
Thank you.
Thank you very much. I'm going to move on to Tony Vaughan. You may wish to elide some of your questions. I leave that to your good sense.
Thank you, Chair. Thanks for all your answers so far. I want to ask about legal advice deserts. I know, Richard, that you mentioned that already. We've had a very large number of legal aid providers disappear, and we have areas of the country where, as you said, there's virtually nothing around. I mean, in Kent, for example, we have, I think, 0 community care solicitors for an area where there is huge litigation against Kent County Council and disquiet and dissatisfaction with how they are complying with their legal obligations. And so I sort of wanted to ask, first of all, in a sort of general sense, I mean, to what extent are those who are eligible for legal aid actually encountering themselves in a desert? I mean, what is the scale of this, and what areas of the country are particularly affected?
Right, well, I've got some specific figures. So this is data from February 2024, and it shows that in community care, 70% of people across the country don't have access to a local provider. 90% don't have access to an education law provider. 85% don't have access to a welfare benefits provider. 44% don't have access to a housing provider, and 63% don't have access to an immigration and asylum provider. We do, I think, with the maps, have information broken down across areas. I don't have those figures immediately to hand, but we can provide that data to the committee afterwards. I think the other thing just to bear in mind as well is what it actually means in practice. So there will be plenty of circumstances in which face-to-face advice is what is required, whether it's because of the nature of the individual or their problem, whether it's because of the value of the local knowledge of the local authority and who to contact there and how they approach things, whether it's because there's a court hearing that therefore needs an individual in person at the court hearing. So remote advice has a place. It can help to plug some of the gaps, but it's not sufficient. And I would go further and say having one provider accessible isn't really sufficient either, because very often that one provider would have reached capacity and won't be taking on new cases, or there might be a conflict of interest, so they can't take on that individual client. There may be a whole host of reasons why actually that doesn't work. You know, they may have had a breakdown in the relationship from previous work the firm had done for the individual. So there are a whole host of reasons why having just one provider may even at that level be insufficient to assure access to justice. You know, if we could at least assure one provider per area, that would be a major step forward from where we are. But you know, that's only a step forward. It's not the end goal that we should be aiming for here. So it's a real problem. It is meaning that people can't get access to the services that they need and that Parliament has said they should be getting.
Yeah. And Richard or Kirsty, I mean, when you have, in your experience, when you have people who are in litigation representing themselves, I mean, what effect does that have on the legal process and the costs that have to be spent on the court time and the judge, etc.? What kind of additional pressures or extra costs does it create in other places when you have somebody in front of a judge without any legal expertise?
Yeah, I mean, it's complicated in criminal cases. It takes, I mean, from my experience and certainly experience of my colleagues, it clearly takes more time because the judge has to be able to explain to the litigant in person, so the defendant in person, what is happening. The directions in order to move the case forward will not generally be complied with by the person representing themselves. So that could also add pressure on the other side. So prosecution might have to take more of the work. The judge might have to come in and take more of the work. So you have, it's difficult to quantify, but all that will happen. In civil cases, and Richard referred to this earlier, yes, definitely the same thing. The judge has to get more involved, and as you probably know, there's actually guidance to judges in the civil area as to how they should actually handle litigants in person. It is that common, and it's useful looking at it because it shows the steps that a judge is expected to take, because you then potentially will get appeals. A decision has been made against the litigant in person. They know they've lost. They're not going to necessarily understand the niceties of this isn't a public law matter, for example, if it's a judicial review case in the administrative court, and therefore they will know that they can appeal. So you're then putting further pressure in other parts of the system, and the same with crime. The other aspect in terms of the data on how quick or how slow it is, you have to have a little bit of caution, as Richard has said, with the quickness of it, because sometimes the data will capture this is very quick because the litigant in person, in fact, is hardly saying anything. I gave an example of a street homeless case, and in fact the application really was that I saw was that the person was there putting their sleeping bag on the bench, and they didn't really have anything further to say other than that. And that in some ways
could make the hearing quicker, but it doesn't mean that actually justice is being delivered for that person, because all the information that is needed for a just decision to be made by the judge is made much, much harder. So you've got what the result is as well.
Are there any other considerations here that we need to bear in mind when we're thinking about how to advocate for more money? Because ultimately, if we can say that by spending on legal aid you are saving money elsewhere, and I heard what was said, and I've seen some of the work that's been done to say that if you spend £1 here you get whatever it is, £3 back. But I mean, in a slightly more short term and in a slightly more kind of proximate way. I mean, your point is, Ms. Brimelow, being careful about the savings on court time, but we have heard other points that have been made. I mean, is there any other considerations here where spending money on legal aid gets you money back in other areas? And I was just wondering, for example, about poverty reduction. I don't know what work there is around whether you spend on legal aid, you get back on poverty reduction, as opposed to just general savings.
There's one specific one that I've wanted to see looked into, and I don't know whether the data exists even, and that is how many family litigants in person have applied for a pension sharing order. Because if someone does not get a pension sharing order and ends up reliant on state benefits for 20, 30, 40 years of their retirement, when they could actually have been having a share of their spouse's pension, that is a huge cost to the state. And I would love to know, are litigants in person in family cases actually applying for pension sharing orders? And if not, how much is the state losing as a result?
May I answer that, Chair? Because I actually happen to have a figure for it.
Right.
In 2024, only 12% of divorces actually involved a pension sharing order. And as you know, it's not mandatory upon divorce, but it is leading to a large proportion of women facing poverty in old age. This is a huge problem that we're facing with women living longer. It tends to be women who are single, divorced or widowed. Divorces tend to occur when women are in their 50s, I believe. I think 25% of marriages end when women are in their 50s. The average pension that a woman has when she reaches pensionable age is £69,000. The average pension that a man has is £205,000. And so without pension sharing orders, or without sort of changes to the law being made, or without legal advice representation being made for separating couples, pension sharing orders are far less likely to occur, leading to said poverty. But I wanted to pick up on the point that actually legal aid underpins a lot of the government's missions. So safer streets, for example, fairer outcomes. We're not really considering that, but actually more opportunities for children. Mr. Miller mentioned the fact that 90% of the population have no local provider for education law. So education law currently has only, under legal aid, only covers special education needs, but there are 400,000 children out there with an education healthcare plan at the moment. There are 1.2 million more children with special education needs, and their parents do need help navigating a very complex legal system in relation to the provisions for their children. So that's yet another outcome whereby legal aid does improve, if not making things more efficient from a financial perspective, it does improve outcomes for people, which is core to missions.
Thank you. If I just, Chair, if I may, one last question on unmet need, etc., before I move on to legal aid remuneration. I mean, there's an argument that within this general duty to make arrangements under Section 1 of LASPO, I've heard it suggested that the Secretary of State could have the power to make a grant to create a legal advice centre. So give, I don't know, £100,000 or £200,000 to somebody to go in and create a legal advice centre in a legal aid desert in exercise of those powers to make arrangements, which I believe has been done in other parts of the country. And I just wondered what you think, who could arrange the kind of recruitment, etc. I just wondered what your thoughts were about, if you had any examples of whether that's happened, and whether you think that that is a model for potentially having a very targeted way of addressing the deserts issue.
I think this is something that would be worth exploring. I think it sounds like something it would be very interesting to develop a pilot as to what that might look like. There's been various different approaches in the past. So, for example, there was a public defender service set up in the early 2000s. It was found that was massively more expensive than delivering services through private practice. On the other hand, we do have a network of law centres. They're set up on a charitable basis. The lawyers don't expect huge salaries, they just need enough to live on, and they are a very effective model for delivering social welfare law services. And so a system just increasing the grants available to the network to set up new services where none currently exist would potentially be a good way to address things. This actually does relate to another issue which is around alternative sources of funding. So one of the areas that's been looked at recently is the uncollected funds from collective actions and judgments made in the Competition Appeals Tribunal. Those funds are available for access to justice projects through the Access to Justice Foundation. They potentially could be a good source of seed funding for setting up a model like that. So I think there are things there that would be well worth exploring further.
Can I jump in very briefly, because I'm aware that some of the MPs in the current government have been trying to set up law centres in various spots, in various legal aid deserts around the country. The anecdotal evidence that I've heard from them has been just how incredibly difficult it has been to staff them, to comply with the various bureaucratic regulations and guidance that you have to comply with in order to have a legal aid contract or to set up a law centre. And so one example that I can think of has gone down the pro bono route. So they're delivering remote advice using pro bono clinics, and that's fantastic. It's brilliant that people living within a legal aid desert are being helped. But as Mr. Miller says, there is more need to explore this with various other forms.
Because I think the power in, I think it's section 2.2c of LASPO to make arrangements to secure legal aid in areas where it's not being met is the power. Sorry. I was going to ask about remuneration for legally aided work. Should I do that before?
Well, I just had a very quick practical question around the university network, because I know University of Essex, where I used to work, has a law centre. Do you know what proportion of universities with a law department have a law centre?
Can look into it. I'm sure. I could obviously University of Essex is one. We know Queen Mary's another. There are a number. I think it's what sort of work they do, however, which and also the supervision that's required. But yes, they are very important, and they do provide some access to people with their legal issues.
I think they cover a national network, and they would cover many of those.
Yeah, the vast majority of universities now, I think, do have law clinics. They do vary enormously in how they're set up. So I know at least one has a legal aid contract. There are others that are set up and only operate during term time, only operate for very limited areas of law. So it is quite a range of different approaches. But I think fundamentally what we have to remember there is the purpose of those law clinics is to teach the students, and the fact that it gives advice to the general public is a byproduct rather than the purpose of those clinics.
We might argue about that. But
it's a valuable service they provide, there's no doubt about it. But it's just about what is the range of services they provide. Some only operate during the term times. They don't manage to maintain services through the holiday periods. Some are incredibly limited over the areas of law they deal with. But yeah, most of them do have some sort of service now, and it is something that's just added to the overall network in the recent years.
And it would be fantastic if that was part of some sort of overarching strategy whereby there was some accountability and governance.
Thank you. Now, I just want to ask about remuneration. So to Ms Brimelow first. So barristers in criminal legal aid have had a 15% increase, and I think solicitors have had a 24% increase since the criminal legal aid review. I just wanted to know, to what extent is that enough? Is it going to stabilise the position or not?
Yes, I mean, the 15% increase, you're quite right, came in at the end of 2022, and it was the result of the
independent inquiry by Sir Christopher Bellamy, which in itself took a long time to report. So by the time that came through to implementation, that recommendation from the report was already substantially overdue, and it was always set down as a starting point, as a minimum, and that was emphasised. There then has been, there's a change of government, but there's then been 18 months, and we had the announcement of an up to 34 million for advocates, which was made just before Christmas. That amount is clearly insufficient. It's actually even less than when it's calculated when you look at the increase of the 15%, because there was other bits added to it. What's happening now is that there is work being done through CLARB, which was set up through the deal with the CBA and the MOJ at the end of 2022, to look at how quickly to try and at least get that 34 million out through the door. The issue here, and the real sticking point that needs to be addressed, is it cannot impact only on cases that come in about another 2 years' time. It has to operate now, because we don't have the luxury of 2 years of barristers working at the rates that they're on, and we can see that in the crisis that is there. So we need to address the delays, address the backlogs. We need to get that money in now, and that legal aid increase. And that's been supported and recognised not only by the Bellamy report, but also by the CLARB report. So they're all independent, coming to the same conclusion. And it's a disappointingly small amount. What else can you get, meanwhile, alternative sources? There's a 550 million pledge to victims. The 550 million is looking at the justice system. The people who are actually giving voice to complainants, alleged victims, are the prosecutors in court. In order for that case to go forward, you also need a barrister defending in court. So we don't see why some of that money could not be considered to actually go to prosecution in particular, who are needed to bring the case. It doesn't, and this has been a mistake from the previous government, in my view, that it doesn't help people that they are given lots and lots of support, which is necessary if they get to court and their case cannot go ahead because there are not the barristers to prosecute it or defend it. So we'd like to see money come from that into there. The other alternative is asset recovery, which it might be we go into more detail on this at another session, but this is recovery of monies through the criminal justice system.
Currently that money goes where? Into the Home Office's
it goes,
coffers?
Yes, Home Office, and it's not going, so it could be used specifically for legal aid, and there's a large amount there that is recovered every day up and down the country. So that, if we could see even that coming in, being used immediately, whilst this pledge of up to 34 million starts to come through the system, that would be at least some sticking plaster.
That's useful. I want to ask also about housing and immigration, and now we've had recent increases since, I think, first since 1996.
Yes.
And so similarly, to what extent, and this is to any of you, to what extent will those increases address those historic funding difficulties?
Can I jump in with a quick figure here? So while the uplifts from 2025 are in housing and immigration are incredibly welcome, it's worth noting that even the highest rate for complex litigation in these areas is still only about half of what an unqualified paralegal can charge a private client under the guideline hourly rate. So we still have a long way to go if we're going to make this work sustainable. I think it's also worth noting that there is a desperate need for uplifts to be made across civil legal aid and not just in housing and immigration. Because when these fees were last set, a pint of milk cost 25p. It now costs about 99p. Where I live, and the average house cost was under £60,000. Inflation has been absolutely exponential in that period of time. And we are currently asking legal aid providers to pay 2026 overheads, office overheads, and 2026 salaries, but they're receiving 1996 fees. It's simply impossible.
Do you think that these increases are going to go anywhere near to preventing this attrition that we're seeing in the system, where solicitors are spending all the time you've referred to earlier doing admin, essentially, that they're not paid for but they have to do as part of the contract? I mean, are we just going to see this trend continue?
I think there's a risk we will. I mean, the increases are very welcome. If you look at the work that we commissioned from Frontier, the indication is that this would at least bring some of the housing practitioners above the level of actually breaking even. So it is progress. It is going to have some benefits. It's going to at least stem the outflow from this work. But I think we come back again to the point that unless firms have an assurance that the rates are going to be maintained in real terms in the longer term, then it's really difficult to make the economic argument for staying within this market. And so that is the benchmark. That's the bottom line, that we need the assurance that rates will not get worse, and then let's see what we need to do to build rates up further in order to increase capacity rather than just stop the capacity from continuing to shrink.
And in relation to areas that are not housing and immigration, but education, welfare benefits, community care, which have not had the increase, I mean, how would you assess the position there as to their sustainability and whether people are going to stick in those sectors if they're not getting paid properly?
Well, there are only 19 firms throughout England and Wales with a legal aid contract to deliver education services. 19, that's insane. The government has taken some amazing steps forward in terms of renters' rights. But if there are no housing providers out there who are prepared to undertake the work, then it's going to be an empty promise that we're making to the public.
Yeah, I mean, from the bar's perspective, this is such a poorly paid area of work, but and also acute need. And undoubtedly this sort of need is what MPs will deal with. The Bar Council made its case for the review of civil legal aid in its Rockler submission, and it hasn't had a response to it. It includes recommending reintroducing legal help scheme in welfare benefit cases, restoring legal aid for housing disrepair cases, and in immigration cases in particular, legal aid could be offered for pre-permission judicial review and for applications for leave to enter or remain based on individuals' Article 8 rights, and it should also be made available in applications based on statelessness. So there's some real concrete and detailed recommendations. Again, we can send that through, but the only widening in conclusion of the scope since LASPO was in the Public Office Accountability Bill, and that was to make non-means tested legal aid available at inquests. Of course, is welcomed, and then there was the small £18 million increase in legal aid in housing and debt. And these are the cases where we see litigants in person repeatedly, and not only in the wrong jurisdiction, the High Court, where they should be in other courts, but also we see them in cases where they are just not progressing forward at all, and then very tragically what you do see is that person is just then out on the street again, and then other social issues follow.
The only other point I'd make is in family. We've got a government that has recently put forward its strategy to deal with violence against women and girls. Legal aid lawyers are a key part of protecting the victims of domestic abuse. And unless there is a significant increase for family legal aid lawyers, those lawyers are not going to be there to provide that protection.
Thank you.
I really underline that. Again, referring to the report that it was huge input from the Family Law Bar Association that was released just before Christmas. Again, we can circulate it, but it makes clear the real acute issue of family law barristers considering leaving or moving away from family law, and we need these preventative injunctions in place to stop domestic violence. And certainly when I was a junior practitioner, it was almost bread and butter that we'd be running around to the county courts dealing with these, and now you just aren't seeing them to the same extent for a variety of reasons. So it really is important if that goal of government is to be at all addressed.
Thank you. We've got two more short topics to deal with. I'm going to try and finish at 4:30 or shortly afterwards, if that's okay with the witnesses.
Yeah, back to me on the financial viability of firms, and we've spoken a lot about litigants in person, and you've already also commented on the effect that the current legal aid system has on the financial sustainability of firms and also the loss-making work that firms are having to do. And I'm really glad, Ms. Brimelow, that you made the comment in answer to Sir Ashley's question that firms are actually driven by the justice of representing people. And I've also experienced that a lot when I was in practice. What I want to talk about specifically is the issue of fixed fees. I've had a couple of meetings with the Society of Clinical Negligence Lawyers, and not only with them but other people that I've come across, fixed fees do not represent often the actual time that is spent on cases, which can be very complex. And I do remember when I was in practice, a lot of firms stopped doing personal injury work, especially the fast track work, and that resulted in more litigants in person, and we've already had a discussion about that. So what's your view on what needs to be done with fixed fees? I'd be interested in that. And also on interim payments. I remember spending £10,000 just to issue court proceedings. The Society of Clinical Negligence Lawyers told me that experts' fees have really rocketed. So how do you represent these individuals who do need help when they are having to spend so much money, which they have to just deal with themselves?
Yeah, and this is a really challenging issue, and there are parts of the legal aid system that run on fixed fees. We've also got the whole issue of fixed recoverable costs for civil litigation now, up to £100,000. There is currently a review going, or a stock take and a call for evidence in relation to fixed recoverable costs for civil private cases. And the evidence we're seeing there is that the costs are simply not set at the right level, and that it is having a negative impact on access to justice. Previously, the position was if you won the case, you'd recover the costs necessarily and reasonably incurred. Yeah. And that seems to be a perfectly reasonable proposition. Now you're getting just a fixed sum, regardless of the amount of costs actually incurred. As a result, successful claimants are losing a large chunk of the compensation that the court has said they should have as a legitimate remedy for the wrong that's been done to them. They're having to pay that in costs that have been incurred because the defendant defended the case wrongly, and they're losing out because of this fixed costs mechanism. So we have some real concerns about that, which we're going to be bringing out in this review that's going on at the moment. On the legal aid side, the fixed cost element is just yet another burden on top of the fact that the rates are low in the first place. And one of the real challenges post LASPO, it was always done on a swings and roundabouts basis, and LASPO took out a lot of the smaller, the easier cases, so you were left with only the bigger and more complex cases, but still getting the same fixed fee. So that was an invisible cut to the rates that happened as a result of LASPO. And we're now, 15 years further on. There's never been any review of the costs. There's never been any analysis to say, well, actually, what is the work required in 2026 as opposed to what was required in 2005 or whenever the rates were set. And the whole landscape has changed, the whole way of doing business has changed, and we're still stuck with the same figures that were set 20 years ago. And as you say, they do not reflect the costs required to do the work. So firms have got a choice. They either lose costs on the work or they stop doing it. Yeah. And so more often than not, they're stopping doing it now.
This was identified as a particular issue, not only in crime, but also in family, that the complexity has increased. So, but then there hasn't been any fee alongside the extra work that is required to be done in order for the case to progress. So we've referred to that, and it is an issue. And there's no way round it. If the additional work is required, there has to be payment for it. I just want to throw up another stat on which might be helpful. It's from the National Audit Office's report on the government's management of legal aid, and that's the 9th of February 24. It said that the MOJ has not increased fees for civil cases since 96, and it reduced fees by 10% between October 2011 and February 2012. So in real terms, fees are now approximately half what they were 28 years ago. So you have that, and then you have increased work demands. because of increased complexity of cases.
Can I take a very quick moment, and I'll speed up the way that I'm speaking, but to just discuss the escape fee trap that we're also in as well, which I think you alluded to. So to get paid an hourly rate, a practitioner currently must do enough work to escape the fixed fee, which is usually by reaching 3 times the value of that fee, which is roughly £800 if the legal help fixed fee is £266. Anecdotally, our members are telling us that if a lawyer spends sort of 15 hours on a complex SEN case or a family case, but the profit costs fall short of that £800 threshold, they're paid only the $266. So ultimately, they're working for free, which, if you want to do the maths, equates to sort of roughly £17 per hour, which is something else that we need to consider, lowering the the escape fee threshold to perhaps something a little bit more manageable than 3 times the original fixed fee.
Just a very final question. So would your view be either to get rid of fixed costs or just increase the levels of the range on which fixed costs are payable? And how would you deal with a situation where, Mr. Miller, as you've rightly pointed out, I remember dealing with cases that ought to be settled, and I've heard this from clinical negligence lawyers, cases that ought to be settled are not settling because the defendant takes a particular view of just wanting to fight it. So how do we deal with that situation where obviously that work, that representation of the claimant has to continue, but the other side does not settle when it ought to? How do we deal with that situation?
Yes, at the moment there is provision in there that says if the behaviour of the defendant in that situation is unreasonable, there is some scope for additional costs being awarded. We've not got very clear evidence as to how that's working in practice, but anecdotally what I've heard is it's really difficult to persuade courts to make payments on that basis or order payments on that basis. In terms of what would work on the legal aid front, it's very difficult because you've always got this conflict between something that's fair in all the circumstances and something that's not too burdensome and bureaucratic. Hourly rates are great in principle, but they are very bureaucratic to assess. The one that works best is the scheme in the Magistrates' Court, where if the costs are up to a certain limit, you get one fixed fee. If they're up to a higher limit, you get a higher fixed fee. And if they're above that, you get the hourly rates. And it's something like 85% the lower fixed fee, 10% the higher fixed fee, 5% escape. So there's budgetary control for government, and the fees that this firm gets broadly reflect the work that they've had to do on the case. And that, out of all the various fee schemes, seems to be the one that seems to be the most acceptable on both sides.
Thank you. Finally, Pam Cox.
Thank you. We'll be closing with talking about cyber attacks. What were the impacts of that recent cyber attack on those who are recipients of legal aid services, many of whom are vulnerable, and what lessons are being learned and applied?
I think from our point of view, the starting point was we were surprised that the legal aid agency didn't seem to have an effective contingency plan ready to go. Having a cyber attack is a very well recognised risk for any public body these days or any commercial body. And it seemed from our perspective that the Ministry of Justice had to build its contingency arrangements at the point that they took their systems offline. So it meant for the next month or so, we were working on, okay, so how do we deal with payments to firms so they don't go under immediately? How do we deal with applications? And so that the fact that there weren't systems in place ready to go did take us by surprise. Having said that, at the point that the decision was taken to take the systems offline and they had to work, Ministry of Justice officials worked incredibly hard. They engaged well with the profession to try to work through what was possible, what was going to work, what was most needed, to prioritise the most important elements first, and to get the systems, or to get some sort of system operational as quickly as possible. So I must pay tribute to the work LAA staff did over that period of time. It was incredibly stressful for everyone, and they really did work hard to try and make sure that the system didn't completely collapse. And so, difficult as it's been for everyone, there was a lot of hard work went into ensuring that things were able to continue. For us, I think one of the biggest concerns is the sheer volume of additional work that firms have had to undertake, in addition to all the stress on them as well. And our view is firms need to be properly compensated for all of the additional bureaucracy that they've had to undertake and will still have to undertake, getting systems back up to proper running now. Systems are coming back online. And so far there has been no indication from the government that they are looking at having a system for paying. It seems to us, we've got a couple of thousand of firms here who have been impacted. Their own data has been leaked. They've had all of this additional bureaucracy. Their clients' data has been leaked. It seems to us logical that there should be one simple central system that says, right, for everyone who's been affected by this, we've got this system for compensation. It would be better for firms. It would be better for government. What we don't want is 2,000 firms each bringing their own separate legal action against the government for what's happened here. It's absolute nonsense to do that. But at the moment, we're just not seeing any indication that the government is willing to look at setting up a system like that. And we would certainly want to very much encourage them to do so.
Yeah, I mean, the position with the bar is that barristers weren't able to claim for civil family legal aid fees for more than 6 months after the cyber attack. And it's very, very difficult for self-employed people. The system is back online, and the backlog of claims are being submitted and processed. And I agree with everything Richard Miller has said about how well the LAA has worked with clerks, with the bar. We have a whole team that's been set up, but a huge amount of work, but the LAA has worked very well and hard with the bar. It has offered the contingency payments, as you probably know, to help with cash flow. This is where the barrister can apply for the interim payment, but it's based on an average calculation of previous billing. So if you have somebody, for whatever reason, hasn't had that billing previously, there then has to be negotiations to get a figure. So it all takes lots of time. Some people have not wanted to get involved with contingency payments because of bad experiences on the LAA recouping. Previously, where they'll suddenly claim recouping from a case from 20 years ago. And so that's in itself therefore caused financial hardship, in that barristers then have had no alternative but to get loans and to get other bridging financial arrangements. The repayment, as I understand it, and in fact in preparation for this session I spoke to one of the clerks who is the representative from the IBC and working on this with the LAA and with the Bar Council, and she told me that the LAA is due to start recouping its contingency payments in February. Not great timing because tax bills come at the end of January, and we hope that there is continued flexibility with the LAA in terms of the financial hardship on barristers. The query, and something perhaps to take forward, is we've had lots of concerns raised about how contingency payments are declared on tax returns, which are coming up at the end of January, and also the VAT treatment of contingency payments. There has been advice that the Bar Council's taxation panel has issued, and at one point we were told that HMRC would be issuing guidance this month about those issues on tax and VAT, but we haven't seen anything yet.
Can the public have confidence in the LAA and its cybersecurity now?
Well, quite. 2 million records dating back to 2007 were leaked. And while steps have been taken forward, and I echo all of the comments that have been made about how exceptionally hard the LAA have worked, there still remain concerns around the infrastructure that we're operating within. And there do need to be lessons learned and steps taken moving forward to ensure that this never happens again.
I just want to add, the LAA's IT systems have been known for years to be fragile. This attack did not come as a surprise. There have been for years calls for major investment to get the system up to a suitable standard. What's happening at the moment is the system is being restored to where it was before the breach. It's not got us to the stage where it's a good, secure, modern system. That still needs to happen. And I understand that is planned, but we could do with knowing a bit more about what that plan looks like.
And I do want to stress just how difficult this has been for firms and for providers themselves. I already mentioned how much unpaid work they undertake during the course of sort of ordinary work. We had a member tell us that the additional work around administration caused by manually doing absolutely everything consumed between 30 to 40 hours a week. That's one caseworker working full time, and this was a family law firm. So that's any number of domestic abuse victims who aren't being helped because that caseworker was dealing with the LAA's data breach as a full-time thing.
We're going to conclude matters there because the issue of public sector IT schemes is one we deal with almost every session, and I think LAA will have to get in the queue behind a number of others in the justice system as well. Can I just end by saying thank you very much to the witnesses who managed to, at the first hearing of this inquiry, to, I think as we expected, to tell us a lot about what the current situation is with legal aid. So thank you very much for that. If I make one brief comment, it's that although we may well point out deficiencies in legal aid, we are looking at other areas as well. So if you have any further thoughts you want to let us have in relation to some of them we mentioned today, other ways in which we can help either address the imbalances, the inequality of arms, or indeed to allow people to get their day in court, or at least get their dispute resolved more quickly, that's the objective that we set out to try it. And can I also thank members of the committee today, particularly those who didn't have a chance to ask everything they wanted to ask, but as I said, had a great deal to get through. So with that, thank you very much, and I bring the session to an end. Order.